The other benefit of having as much time as you need for temporary orders as a litigator, in my opinion, is people want to tell their story. People also don't have any realistic expectations of what happens in a courtroom. And so if you can go do that at temporary orders, and temporary orders are, the time frame for judges depends obviously on their docket, but you're not given much time, definitely less than you'd be given for trial. But if you can go at temporary orders and tell your whole story, in my experience, those cases, regardless of the outcome for your client, are more likely to settle.
I actually believe that's true. But just my experience with people is that they just want to be heard. And I've had people who lost on every claim come up to me after the hearing and approach the bench and say, finally, I got to tell my story. I'm sorry it came out this way, but I feel better. I know you were listening. I could see it.
Yes.
Procedural due process is the person's perception that the system allowed them to be fairly heard. That is more important to a person's accepting the outcome than the correctness of the outcome. That is where the demeanor of your judge and the amount of time comes into play so strongly. You can win and feel completely shafted by the system, or you can lose and feel like you had a fair day. And that's the procedures and the patience and the flexibility of the court in letting you tell your story, just like you suggest.